Well, thank you very much for inviting me, Matt. And it's a great pleasure to be here, especially as this is actually my old undergraduate college. So it's kind of like coming home. We were talking about ordinary decent people in the previous session. And some of you, I'm sure, will know that in the days before the Good Friday Agreement in Northern Ireland, different rules applied to terrorist offenders and other offenders in Northern Ireland. For example, if you were released, if you convicted of murder and released, if you were a terrorist offender, you did not receive any supervision because the probation service did not feel that they were able to offer supervision to those people given the kind of communities they would have to go into, etc. Whereas if you were not a terrorist offender, then you would have supervision in the ordinary way. And so, as this was a normal feature of the Northern Ireland criminal justice system, people had to distinguish between terrorist offenders and others, and they had to think of a name for the others. And so the name that came into being was the ODCs, which was an abbreviation that was commonly used, which meant ordinary decent criminals. So we're now talking today, at this final session, we're talking about the sentencing of ordinary decent criminals. And sentencing is, it has been said, is a Cinderella topic within criminal law scholarship. And if that's the case, then personal mitigation or equity factors, I would say, is probably Cinderella's illegitimate baby. It's a very, very unusual topic within sentencing. It's not the dominant topic. And frankly, neither the term personal mitigation nor the term equity factors really quite captures what we should be talking about here. Equity factors, as we'll see in a minute, is a Swedish term which isn't normally used in England. Personal mitigation is used, but it has kind of connotations of special pleading, lenience, etc., which is all wrong, because what we're really talking about is offender-related issues that should justifiably lead to sentence reductions in a democratic state. Another of the special features of sentencing, by comparison with the rest of criminal law, is, of course, that case law doesn't exist in quite the same form as it does in ordinary criminal law. There are cases, but they're advisory rather than binding. So we have a limited supply of them. And so we also rely on empirical research. And the best piece of empirical research on personal mitigation is this piece by Jessica Jacobson and Mike Huff, which was published 10 years ago. One of the things that they highlighted was the limited amount of guidance on personal mitigation from the then Sentencing Guidelines Council. Sentencing Guidelines Council has now been replaced by the Sentencing Council, and in my view, the Sentencing Council also has not given much guidance on this particular topic. My good friend Julian Roberts, who who's Professor of Criminal Justice here, is unable to be here today because he's presenting the prizes at his old school. But I sent these notes to him, and he said, well, he rang me up this morning and said, well, what exactly do you want by way of further guidance? And I think that's a reasonable question. And I think in a way it's not entirely clear because we only have empirical research 10 years old. But the empirical research 10 years old is a bit sobering. So, for example, the same case was given to 40 judges and on a number of issues they disagreed quite sharply. So, for example, does a letter from the victim's family in a death by dangerous driving case make a difference to the sentence? 19 of 40 judges said yes, it would make a big difference. 6 said no, it would make no difference, and the rest were in between. If someone has a good character and commits an offence of actual bodily harm, and the plea is that this was a moment of madness, completely out of character, etc., does this make a difference to the sentence? Is it mitigating? 9 of the 40 said yes, it's a big factor. 9 of the 40 said no, it's not relevant at all, and the rest were in the middle. So if that kind of disagreement is still around, then it's easy to support Jacobson and Huff's suggestion that we do actually need a bit more guidance as to whether things like that do justifiably mitigate or not. You will have seen from that that the whole discussion of this topic, both in terms of the Sentencing Council and in terms of academic writing, and every standard book on sentencing has a chapter on personal mitigation, but it tends to be based on factors. Does this factor mitigate? Does that factor mitigate? And so on. And Joanna Shapland from Sheffield University, in a 2011 paper, said that perhaps that was a mistake, and we should start from philosophical principles when thinking about mitigation and what should justifiably lead to sentence reductions, rather than offering a list of factors. And I agree with that view, and so what this paper is a very preliminary attempt. It's very much in the Hannah Quirk mould of first draft of what I hope will be an article. It's a very preliminary attempt to begin to think about what the principles might be that would justifiably allow a reduction in sentence on the basis of offender-based factors. There's an article by an Australian called Austin Lovegrove, which was based on public views of real cases, and he grouped the factors that the public members were, it was in focus groups, he grouped the factors that they talked about into 3, which are culpability, rehabilitation, and mercy. None of these words are perfect, but they, I think, give us a starting point, probably not much more, a starting point for thinking about what might justifiably count as an offender-based mitigation. Culpability has to be seen in the context of the fact that we are now, certainly in England and Wales, dominated by what is now called in the Academy penal censure theory. Penal censure theory says that the first role of sentencing is to censure people for their actions and to censure them in accordance with the seriousness of the offence as judged by its harm and culpability. And if you look at Sentencing Council guidelines, and of course Dame Maura is a member of the Sentencing Council, you will see that steps 1 and 2 of Sentencing Council guidelines are completely dominated by harm and culpability issues. Personal mitigation is a non-statutory term. It's usually seen as synonymous with offender-based mitigation, and mostly, but probably not entirely, it's outside the harm culpability framework. But some offender-based matters can, of course, affect culpability, for example, mental health issues. And, of course, here we come to an interesting intersection between this conversation and the conversation in the first talk, what exactly is culpability that reduces the seriousness of an offence. The Swedish Penal Code is where we get the term equity factors from. The Swedish Penal Code, section 29 of it, runs a distinction between the penal value of the offence, which is based on harm and culpability, and equity factors, which are non-culpability mitigating factors. But they have quite stringent criteria for offender-based mitigation. So, for example, I've put on the sheet, in consequence of a mental disturbance, the accused had a markedly diminished capacity to control his actions. And there are one or two other similarly tight criteria for having an offender-based dimension within the culpability part of the penal value. But then in a separate section of the penal code, they allow the penal value to be modified by reference to equity factors, and these equity factors are of various kinds, and we'll come to them later. Jacobson and Huff, in their, of course we don't have the distinction between a penal value and equity factors in England. Jacobson and Huff did use the concept of culpability in their empirical description of what they saw in the Crown Court and what they talked to judges about. And they said, towards the end of their report, that they had identified a number of culpability-reducing factors, which included youth, mental health problems, pressing need, previous good character, and exceptional disadvantage. So the question arises, are these really culpability-reducing factors, or are they something else? Now, maybe this doesn't matter to the sentencing judge, and Dame Maura will no doubt comment on that, whether actually it is a culpability issue or you might reduce on other grounds. But certainly, from an academic point of view, it's quite important to know why we think it's appropriate to reduce a sentence. I have some reservations about certainly whether everything in that list could be said to be true culpability. For example, the pressing need factor, which is raised by them, I guess that could include starving. The actual case that they mainly rely on is interesting. It's basically a Nigerian man who'd been brought to Britain in effect as a slave to work for a Nigerian family. And he managed to escape through the help of a friend, and then he was arrested in an attempt to open a bank account with a false Nigerian passport, and was duly convicted. The judge, however, was extremely supportive of him, precisely because of the circumstances. I, too, would be very supportive of him in those circumstances, but I'm not sure that we can really say he has a reduced culpability, and that's the kind of problem that is raised by this kind of case. And I know that exceptional disadvantage is in Jacobson and Huff's list, and Roxana has raised that earlier in the day, but I am coming back to that. So let's move to the second of Lovegrove's possible criteria for reduction, and that he calls that rehabilitation. And this is really very interesting, and I think goes to the heart of some of the main issues that sentencing theory now has to get to grips with. This is not the occasion for a lecture on sentencing theory, but sentencing theory has changed quite a lot in the last 20 years. and is now dominated by penal censure theory. But there are various versions of penal censure theory, and one version of penal censure theory really isn't very interested in personal mitigation or equity factors. It says something like, well, that we are sentencing on the basis of the seriousness of the offence, and the seriousness of the offence has got nothing much to do with rehabilitation. However, another view of censure theory, espoused especially by Anthony Duff, Emeritus Professor at Stirling, says that we need to see any kind of sentence as a communicative act of censure. And when we censure somebody, we intrinsically also want that person to change. Think about ordinary families, schools, colleges, whatever. Yes, we hold people to account for their wrong actions, but we simultaneously want them to change. And this has been well expressed by another philosopher called Fricker, where she says that basically censure and blaming, if done properly within a properly communicative framework, is censuring, but is also trying to prompt a change for the better in the behaviour of the wrongdoer. Now, if that's right, and I think it is, then sentencing is not just about imposing a sentence on the basis of harm and culpability. Certainly it is about that, but it's also about thinking about how the person can be moved to the next phase within the framework of the censuring process. And Hannah Maslin, who used to be of this university, maybe still is, I'm not sure, she's a philosopher, has produced this notion of responsive censure and written a very good book on how remorse and voluntary reparation, within the framework I've just described, remorse and voluntary reparation, which is recognised as a factor by the Sentencing Council, can be seen as an appropriate response within the framework I've just been talking about to the censure, and is therefore good grounds for mitigating. Similarly, much of my own work, my own empirical and theoretical work in the last decade has been about desistance from crime. It's still not widely enough known that almost all offenders eventually stop offending, and that the peak age for the peak time of reduction of offending is actually in the early 20s. So desistance is a much more frequent occasion than the Daily Mail believes it is. And we also know from that empirical research that people typically particularly a persistent offender, doesn't desist all at once. He reduces his offending before he stops it, just like you do when you're stopping smoking. And so, okay, suppose there is somebody who is taking serious steps to reducing their offending. Is it right and they commit a further offence because they meet a friend who leads them astray one evening or whatever? Is it right to reduce the sentence on the basis of the serious attempts that he has been making? The Sentencing Council, I'm glad to say, says yes, and I agree. And so what this is doing is saying we need to build into our sentencing theory not only the dominant stuff about seriousness of the offence, but also about the response. And the response, appropriate or otherwise, is a good reason for thinking about an offender-based reduction in the sentence. So somebody who, as you know, probably you know, usually lots of previous convictions is an aggravating factor, is if somebody is seriously trying to desist, and they do in large numbers, then that is to be set, in my view, to be set against the aggravating factor of the previous offending. Lovegrove's third category is mercy. This is a very heterogeneous factor, and so here are a few factors that have been included in the concept of mercy: advanced age, poor health, long time since the crime was committed, the defendant makes attempts to alleviate the harm he has done after he's done it, the defendant is a sole or prime carer for dependent relatives, the defendant has a difficult or deprived background, the defendant, this is an actual case, rescued someone from drowning a week after committing the offence. It's a very disparate list. All of those have, in some case or other, been thought to be mitigations. And so the search for principle asks us to consider what is the ground that might underpin this. I think the best way of looking at this is to talk about fairness, particularly unfairness, and to ask the question, is it fair in all the circumstances, or would it be unfair in all the circumstances to apply, in Swedish terms, the penal value? So in other words, if we simply calculate the offence, the seriousness on the basis of harm and culpability, would it be unfair if we simply applied that? And my own answer in the case of the rescuing the child, whatever, would be, no, it wouldn't be unfair, because the act of mercy the act of rescue has got nothing to do with the crime. But in other cases, of course, the situation is different. But the grounds for that fairness reduction might vary in different, and that's one of the key problems that remain here. The grounds for that fairness reduction might vary quite a lot in different circumstances. So let's take the Sentencing Council's sole or primary carer mitigation, which is a regularly included factor in Sentencing Council guidelines. I think rightly, I think Dame Maura will correct me if I'm wrong, but I think it is usually applied particularly in cases which are on the cusp of a custodial sentence, where the view of the sentencer and of the council is that the penal value of the offence can be partially set aside by wider considerations of social policy relating to care in the community. But that justification, which I think is sound, is contrary to one that has been suggested by Andrew von Hirsch and Andrew Ashworth, which is that all of your mercy-based factors must have some kind of quasi-retributive dimension. There is no quasi-retributive dimension here. It's about social policy. But then, if social policy is the issue, what about deprivation, Roxanne? And here, this is very difficult, and as I've already indicated, Jacobson and Huff recommended that it would be helpful if the Sentencing Guidelines Council would give indication on this, and they put it in their culpability factor. I'm not sure whether it is appropriately put in the culpability factor. As far as I'm aware, the most recent empirical research on social disadvantage and crime paints quite a complicated picture. This is from my Cambridge colleague Per-Ove Wikström and his colleague Kyle Treiber. And this says that coming from a disadvantaged background is not a strong predictor of crime involvement, but a large proportion of persistent offenders come from disadvantaged backgrounds. Two different statements, both true. Coming from a disadvantaged background is not a good predictor of becoming an offender, but a large proportion of persistent offenders come from disadvantaged backgrounds. It's a paradox. The explanation of the paradox, according to Wikström and Treiber's research, is that more young people who experience childhood disadvantage are likely to develop a high crime propensity, and that's because of exposure to social circumstances beyond simple disadvantage. That is to say, things like poor parenting is more likely to arise within socially disadvantaged circumstances, but it's the poor parenting, not directly the social disadvantage, that leads to the crime. And Wikström argues, quite forcefully actually, if you talk to him, that for these reasons, it is wrong for sentencers to simply have a reduction in the offending for the reason of social disadvantage itself. I think I agree, but that doesn't mean that disadvantage plus, or in Brexit language, disadvantage plus plus, it probably is a good reason for mitigating. That then leaves us with the puzzle. Is it appropriately handled, and judges don't have to worry about this, but academics do, is it appropriately treated as a mercy factor or an unfairness factor? It would be unfair to apply the penal value given the disadvantages of the defendant, or do we put it in the culpability box? I'm more inclined to put it in the unfairness box, but who knows? And I'm running out of time, so my conclusions are briefly fourfold. One, the whole responsive censure thing does seem to me to be extremely important, and in an era of penal censure theorizing, we are a bit in danger of forgetting the importance of the individual and the role of sentencing within the criminal career. And so the notion of the response is very important. And in Jacobson and Huff's study, about 40% of mitigating factors taken account of by judges were of this type. Secondly, I agree with Jacobson and Huff that we actually do need a bit more guidance from the Sentencing Council. Thirdly, but I've just put this on the table without discussing it, that a major mitigating factor usually treated as personal mitigation is no previous convictions, and I am aware that this does not fit very well into the threefold characterization, theorization that I have developed. And I note that the Swedes put it in a separate box as well. They call this, they have a separate box for length of criminal career or no criminal career, separately from penal value and equity factors. And I'm wondering if that's telling us that there's something different about this, but I haven't solved that yet. And finally, I just do want to repeat that this whole topic, despite its Cinderella-like status, is, in my view, very important.
Well, the chimes of midnight and the approach of a pumpkin. I recognise it's 10 to 7 on a Friday night, and I am sorry. Just so that there's some context to what I'm about to say, I was a criminal barrister for many, many years. I did more defence than prosecution as a junior. I got silk in 2001, and after that exclusively defended in serious organised crime, serious fraud, gangland, drugs, murder, that sort of thing. I've been a judge for 4 years, but I sat as a part-time judge since, I don't know, for about 15 years before that. And so I have done the sentencing at the lower level, the petty, day in, day out, small level theft, burglary, that kind of offending. And since I was made a judge, it's now up into decades when I pass a sentence, because I sentence for murder or terrorism. The work of the Sentencing Council has become much more sophisticated, or at least we think it has, we believe it has, but at the same time it's become much more hidebound by statutory provisions that determine sentencing. I'm not going to deal with murder sentences, although we touched upon them earlier, other than to say that because the starting points within different categories are established now effectively by statute, that has massively increased the sentences that are imposed for murder. And at one time, the average sort of time served by somebody serving life for murder was about 12 years. Now, young men who stab one another in the streets will get a starting point of 25 years. And so that has hiked up lots of sentences for violence generally. And so that is, I'm afraid, and I don't mean this as a cop-out, but that is outside our remit. That is simply what Parliament has achieved. Equally, we have statutory minimum sentences, so 5 years for carrying a firearm, 3 years for a third burglary. And so you will undoubtedly think there has been an increase in levels of sentencing. Empirically, that is right. I don't say this is the only explanation, but it is in part an explanation for why that has happened. The Sentencing Council has an approach, and its approach to sentences to provide the day-to-day manual for judges who sit in the Magistrates' Court or the Crown Court, who deal with all the sentencing. That's what they need. They need a handbook. Where do I start? Where do I go to next? What do I take into account? Where do I end up? So that's what we do. It isn't, I'm afraid, high academic work, although we always have an academic member of the council, and it is informed by academic thought. But what we are providing is a day-to-day guidebook for judges. The policy is to look at the culpability first. Culpability is a mixed bag. It is generally factors that relate to the offence, but it almost always, in fact I think always, includes factors that relate to the offender. So I'm looking now at the cruelty to children because it's one of the most recent, and because it is the sort of offence it is, this is one of the ones that has greater subtlety in it than simply theft or drugs, where quantities and values are easier to determine. And so in the culpability we have high, medium and lesser, and amongst all the things you might expect, which is the level of injury over a period of time, so multiple instances of causing cruelty to a child. In amongst that and the level of force used and things of that sort is, for example, the fact that something might be a momentary or brief lapse of judgment, or that the offender themselves is a victim of domestic abuse. So it's culpability, but it is a combination of offender and offence-related factors. Then you move on to harm. Well, that is easily quantified in one sense. It's very serious, it's in the middle, or it's at the bottom, and you measure the injuries, that perhaps, or the damage done to the child long term. But then you move on to those factors which relate to the individual. Now, having been brought up as a Roman Catholic and educated by nuns, I slightly fear the use of the term mercy or retribution. I would rather this was less involved in that sort of language, but we know what we're talking about when we use those terms. And previous convictions, when the judge has regard to the nature of the offence and the relevance and the time since the last conviction, can aggravate the position. So put simply, if somebody is a burglar and they burgle regularly, and they last burgled 6 months before this burglary or 6 weeks before this burglary, those will aggravate, or may very well aggravate, the sentence. There is also a list, for example, of other factors which aggravate. In other words, deliberately trying to put the blame on somebody else who is innocent, committing an offence whilst on licence. Those sorts of things you can see, I think at least, as a matter of common sense, that makes the position of the individual more serious, or may do. But we then do provide a list of what I would want to continue to call personal mitigation, but which I accept might be identified as equity factors, or those factors calling for the application of mercy. And they are no previous convictions, or no relevant or recent convictions. Now, I understand that may have little to do with broader factors, but for the individual who is about to be sentenced, or for the family whose house was burgled, or for society as a whole, that is a very relevant and interesting and compelling factor. Remorse. Now, remorse is a very difficult one, I think, because we are dealing with mental health guidelines at the moment. We're working on those. And a number of psychiatrists have pointed out that there are a number of mental health conditions which means somebody simply is incapable of feeling remorse or expressing remorse. Now, is that person going to suffer more, get a worse sentence, because they are simply incapable of expressing something which somebody else might be able to express, and if genuine, or perceived as genuine, might very well reduce their sentence? The sole or carer for a child or a dependent relative, serious personal medical condition, mental disorder, cooperation with the investigation. These are all factors which are set out, not all of them in every guideline, but most of them in most guidelines. They are not exhaustive. They prompt the judge to take into account these factors, and mercifully, to use the word I don't want to use, most defendants are still represented, and whoever appears on their behalf will stand up and say, this young man may be 25, but in fact he's barely literate, or he has had this sort of background, he suffers from this sort of medical condition, he is responsible for looking after his mum, whatever it may be. And so these are personal factors which are brought to the attention of the court, and the court should take into account before passing sentence. Can I just deal with a couple of specific points? I'm not sure, and the council still holds to the line, that it cannot give more detail of potential personal mitigation. And I think that may be right for this reason. I was trying to remember the quote earlier from Anna Karenina, which I can't properly remember, but it's to do with families all being happy in the same way and unhappy families all being different. If there is a story to tell about an individual, then it is likely to be different in each individual's case. And if the obvious points to be made are highlighted by the list of the sort of factors I've given already, then they ought to be capable of being identified to the judge and taken into account by the judge. It's impossible to list all possible permutations. There is, I'm afraid to say, a huge amount of case law in this area It is only advisory because courts will say, well, what happened in that case can only guide me so far as this case is concerned, because this man is an individual. I am not going to sentence him in the same way, even as I sentenced Bloggs last week. That would not be right. That would not be equitable, to use the other term I didn't want to use. And so there is a huge amount of case law, and for anybody that spends any time in the Court of Appeal, the vast majority of the work that the Court of Appeal does is dealing with sentences that have been imposed. Slavery and trafficking is actually a very substantial mitigating factor, and in some cases can take a case out of being prosecuted at all. Francis will know, and I can't now remember, is it J? GS, forgive me. A woman who was trafficked, who we ultimately formed the view had nonetheless gone on voluntarily, in the broadest sense, to become involved in criminal activity, nonetheless had substantial mitigation because of the background facts. And that certainly is, and in my view, should be. It's a very difficult area because where the line is to be drawn between those who, rather like the 14-year-old Vietnamese boys who find themselves working in cannabis farms, having been smuggled in the back of the lorry, cannot be said to be acting in any voluntary sense at all and will not be prosecuted or should not be prosecuted, all the way up to people who simply take advantage of the fact that they were trafficked in and are now free from any connection with anybody who will be prosecuted and punished, although they will have this mitigation available to them. And I think finally, because I'm conscious of the time, can I simply make this observation about the discrepancy in judges who were asked about whether or not they would be influenced in a letter from the deceased's family in a death by dangerous driving. Instinctively, and I've seen families come to court in these circumstances to speak on behalf of the defendant when tends to be young men, a young man has driven in away and killed his best friend in the passenger seat of the car. The dead young man's family come to court and say, they were friends forever, we don't want to see him punished. Instinctively, one's heart goes out to them. You want to say, of course, that mitigates your position. But has that young man done anything less than somebody in his position for whom the dead boy's family will not speak? And the answer, so far as the sentencing judge is concerned, ought in fact to be no. They're in the same position. He may have the consolation of knowing that the dead boy's family have forgiven him. But in reality, his offending, the consequences of his offending are no less awful than somebody in the same position without that support. So I'm sorry that was a bit hit and miss, but I was trying to pick up on Professor Bottom's points as he'd made them. Thank you very much.